Hello, and welcome to the Heart of Law podcast. My name is Mirena Umizaj, and I'm your host. As most of my listeners know, I use this platform as a source of inspiration and education. Work can take a toll, and if you're pushing instead of being pulled, it's hard. And I have made it a priority to find reasons to be pulled. And that sometimes means working with people I love and respect, but also bring heart into their professions. This inspires me to get better at my own craft, but my hope is that is also inspiring you, my audience, in the same way. There are so many outstanding people in the legal profession today that create tremendous value, including my guest today. I have invited on the show John Cattie Jr. John is the managing member of Cattie and Gonzalez, PLLC. His firm resolves healthcare liens, maximizing net settlement proceeds, and protects future access to Medicare and Medicaid benefits. All of the things that lawyers hate to do, plaintiff lawyers hate to do. And this is from experience as a settlement planner. John started in the healthcare subrogation space with Gerritsen Resolution Group in 2008, addressing clients' Medicare set-asides. Recognizing that clients prefer to work with lawyers, providing legal advice, he left Gerritsen and launched his own law firm in 2016. Today, John works with clients on single event and mass tort cases to obtain the most favorable lien resolution results in the country. John also helps protect clients' future access to Medicare and Medicaid benefits. He has reviewed over 15,000 distinct fact patterns for Medicare set-asides purposes. Multiple federal and state courts cite his analysis very favorably. John, welcome to the show.
Mirena, such a pleasure to join you today. Thanks so much for the invitation to sit with you for a few minutes today.
Oh, it's my pleasure, John. I would hear your name at conferences across the country, especially on the Medicare set aside for single event cases. And, other people would build presentations at conferences based on your work. And I always wondered, who is John Cattie? So I always knew who you were. And of course, in the last few years that we've known each other personally, I see why people want to work with you. And I certainly, I love working with you. And hopefully we'll be working together on some really important and meaningful projects. But the reason why I was compelled to have you on today, John, is because of Camp Lejeune. And we'll talk about other topics that I know you're very well versed, but this is sort of front and center today, especially in the mass tort world. I'm not aware of anyone else thinking or talking about what happens with lien resolution once the Camp Lejeune cases resolve, which is why when you and I had connected at some of the conferences that we've attended lately, especially since the Justice Act passed in the Senate, every time we talk, you have something is captivating and it's interesting about what happens once the cases resolve. And as you and I know, most people don't think post-settlement. They're just trying to figure out, how to get cases. And I'm talking about law firms, plaintiff attorneys. They want to get the cases. They want to do the workup that's necessary for those cases, keep up with client communication. But there is really no overarching strategy from sort of beginning to end because there's so many unknowns. But what you do so well is you try to think of all the possibilities within the realm of the MDL world of what could happen. So give me some of your thoughts, high level for our audience, especially the attorneys that are working on these cases, how to think about what happens once an offer has been made by the government.
Yeah, absolutely, Mirena. And fully recognizing that I'm doing the work that no personal injury attorney wants to do. They don't want to touch it. They don't want to handle or think about liens. They don't want to think about or handle protecting a victim's future eligibility for Medicare or Medicaid. In a lot of ways, I consider myself a trash man. when it comes to certain things. The personal injury attorneys, they are the stars of the show. They are front and center. They're that bartender who everyone comes to see at night. And I'm the guy who's cleaning up the bar at the end of the night to make sure that the next day things are clean, pristine, and ready to go for the next night's show, right? But if the trash isn't being taken out, if the bar's not getting cleaned up, then that star bartender, that personal injury attorney's not going to perform as well as he or she could. And that's really what we do when we come in to think about liens, protecting future benefits, whether we're talking about in the single event context or in an MDL, a mass tort, or in the context of Camp Lejeune. It all comes together at some point in time with the overall goal of maximizing the amount of net proceeds that are going to go in the victim's pocket. And that comes in a couple different ways, right? Number one is the damage buildup, the case analysis, the amount of the demand, and ultimately the offer that can be accepted by the victim. That's the work that the personal injury attorney is doing. But by the same token, if there are liens that are in existence that need to be addressed, and if we're talking about any sort of bodily injury claims, there's going to be liens that need to get addressed. The ability to identify, recognize, verify, and resolve those liens to minimize the amount of those paybacks is only going to maximize the net proceeds that go in the victim's pocket. And that's really the world that we live in. And this Camp Lejeune litigation really is posing a very unique proposition when it comes to how healthcare reimbursement obligations need to be addressed in order to get to that end point, that point where funds can be dispersed and attorneys can take fees and disperse balance of proceeds to the injury victims.
So what typically happens in MDLs, right, is at the very end, when there is that global settlement, everybody's scrambling, right? And you are trying to resolve, obviously, the liens. You are setting up a qualified settlement fund. You are, talking to your clients, making sure, if they're alive, you can find them. If they're dead, that you're opening estates. I mean, there's just so much that goes on at the end of the case. And it becomes, I think, the most stressful time for everybody involved, right? And we have big companies that get involved to try and do these global resolutions. And so in most of the time, those companies do take the heat because they're not moving fast enough. And sometimes they are doing the best they can. And other times, there's cracks. But what can we do in Camp Lejeune, do you think, to prevent this chaos that we typically see in MDLs at the last stages?
Right.
How can this be approached differently?
Think about it from the perspective of an injury victim, someone who has been injured by the contaminated water and for years and perhaps decades have been injured and are waiting for this moment. And finally, there's an offer from DOJ on their case, right? At that point, there's that light at the end of the tunnel. My goodness, this is almost done. Let's get it wrapped up. But to your point, there's so much that's going on from that point going forward that to be able to resolve the liens in an appropriate way is one additional layer that if it's not addressed more proactively on the front end, that potentially that wait time could be extended for that victim. And given the tens and perhaps hundreds of thousands of injury victims that we'll be talking about when this is all said and done, the likelihood that someone might get shuffled to the back of the line because they're not ready and prepared to act on an offer because of a lien issue is legitimate and real. So what I've been advising my clients in having these conversations about their inventories of Lejeune cases is, number one, you need to have a clear understanding of what benefits these victims are enrolled in or entitled to. Okay. You can't resolve a lien unless you know that there's a lien in existence. And the way to know that is to understand which of your clients are on Medicare, and not just any Medicare, right? We need to know, are they on traditional Medicare A and B through the federal government, or instead, are they on a Medicare Advantage, a Medicare Part C plan? There's 4,000 of those around the country this year alone. So figuring out which one of those you're going to have to talk to, that's work on the front end to figure that out. Or if they're on a Medicare prescription drug plan, a Part D plan, there's 801 of those plans around the country this year. Figuring out which one you're going to need to talk to is important. So understanding which part of Medicare the individual client is on, you go through the same exercise for Medicaid, by state. Or if the state has outsourced that to a managed care organization, then you have to figure out who to talk to there to resolve that. VA and TRICARE. And those are just the lien obligations that are enumerated within the Camp Lejeune Justice Act itself. That doesn't even begin to touch the types of perhaps private liens that need to be thought about, ERISA liens that need to be thought about, FEBA liens that need to be thought about, and other reimbursement obligations. So there is this big ball of, again, trash that needs to get addressed. And the way to do it the right way, in order to shrink the amount of time it will take for an attorney to accept an offer from DOJ, get settlement proceeds in their trust account, take their fees, disperse the balance, is to do as much work on the lien issues proactively as they can up front.
So one of the arguments, right, I brought this issue up with lawyers. Again, the settlement planner in me is saying, let's try and take care of this now so that we can shrink that time in the back end. But the argument has been, we're going to do everything we can to get the government to waive these liens. So why do all this work and go out and do fact gatherings and pay people to do all this research on thousands and thousands and thousands of people when we might just be able to get this waived? What's your thought there?
You might be. And isn't that the best case scenario, right? Is to force the government during negotiations to waive in full any sorts of reimbursement obligations or offsets related to VA and TRICARE, Medicare, and Medicaid. And for me, that's the best case scenario, right? But it's dangerous to hang your hat solely on that strategy. And here's why, okay? In my opinion, of those three, VA, Medicare, and Medicaid, it's probably the easiest to convince the government to waive VA and TRICARE, okay? Because we're talking about DOD, we're talking about Lejeune, this is military, directly on point, right? So if there's one of these that's going to get waived, I would think it would be VA and TRICARE over the other two, okay? Now, with respect to Medicare, if we are talking about these not in the Camp Lejeune context, but perhaps in a single event context, we might have some very strong arguments to get Medicare to waive in full their rights of recovery, okay? Especially given the fact that there's a certain population of victims here who were on the base and their time on the base stopped sometime before December 5, 1980, which that's the date the Medicare Secondary Payer Act was enacted. And thus, this really becomes, from Medicare's perspective, an exposure case, which, hey, if all exposure predates 12/5/80 in a liability case, Medicare doesn't have a right of recovery. So ordinarily, strong arguments there for full waiver, but we're not in a single event run-of-the-mill case. This is Camp Lejeune Justice Act, and we don't know exactly how this is all going to roll out yet. So I'm a little less confident about being able to get full waivers for Medicare. Not to mention the fact that we're not just talking about Medicare AB traditional, run by the federal government. We're also talking about 4,000 Medicare Advantage plans that are run by private companies like Humana and United Healthcare and Kaiser and all these other plans who may or may not, at the end of the day, have to fall in line with what traditional Medicare does, okay? If we look at it from the Medicaid perspective, now we're talking about a healthcare system that is federally funded for most of it, like 2/3 funded by the feds, 1/3 funded by the states, and the states are the ones implementing that healthcare insurance. So can DOJ force the states to waive in full any sort of Medicaid liens? I don't know the answer to that as I sit here. So relying on that strategy and not doing your due diligence up front, I think is a little bit dangerous. And I think the prudent attorneys out there realize that conducting that due diligence and being ready for the situation in case we can't get full waivers for all of those is really a best practice here.
It's such a conundrum because obviously to do this work requires resources. And when you're litigating a case this big and somebody is working on 10,000 Camp Lejeune cases on a contingency, and they're paying for staff and they're paying for the call center, whether it's being outsourced or it's in-house, you're retrieving medical records at a cost. It becomes very, very expensive and time consuming. So when you're, again, and I know you specialize in this, but just kind of to put things in perspective as an attorney's looking at the big picture, what, in terms of order of priority, where do you think this falls?
I think the answer to that, Mirena, depends on how successful you want to be in resolving the lien and how quickly you want to get funds in your trust account, right? I think if you are an attorney who wants to get the best possible lien results to maximize net proceeds and get those proceeds in the door as quickly as possible, then you are proactively addressing these issues. If you are an attorney who is more along the lines of checking boxes to get this done in order to be complete and thorough in your case, then it's not as high of a priority. And that, in our experience, that's the way that these issues have been handled, and for good or for bad. And we've seen that roll out in the mass tort MDL context with varying levels of success, right?
No, it's a fair answer, right? I'm thinking how to best serve this to the plaintiff community, because again, I think they are distracted and there is a lot going on, especially as you know, leadership was just established. And from the conversations I've had in the past 30 days, this isn't even something that comes up yet, right? There's been meetings with the Department of Justice. I'm not privy to those, but I don't believe that this is something that they're inquiring, because if they were or asking questions, then the plaintiff lawyers would be calling you or calling me. But what do you think the government is doing, if anything? Do you think they're strategizing on this issue? Do you think they're crunching numbers? I mean, this could turn out to be, depending on how it is structured on their end, this might be incredibly expensive, right? Or they can be really smart by figuring out how to offset, right, these liens. So what do you think is happening behind the scenes? Or is there anything happening?
So I think we can look at what has happened over the past 12 months, and we can interpret some data to give us a hint at what's going on that side, okay? Here's what we know. There's a lot that we don't know about this, but here's what we do know. We know that we are just over 1 year into the Camp Lejeune Justice Act being signed into law. We know that there's now just less than 1 year left to file administrative claims with Navy JAG. We know that the number of claims filed to date ranges anywhere between 70 and 100,000. And we know that, based on what we've heard, that Navy JAG has not touched a single claim, has not approved a claim, has not rejected a claim. They're not touching claims. They're letting the claims run through the 6-month period and then letting the claimants figure out whether they want to move forward and file suit in the Eastern District of North Carolina. Okay? Mm-hmm. All of that, to me, signals DOJ's partial strategy of wanting to figure out exactly what the universe of Camp Lejeune claimants is going to look like, right? Mm-hmm. Because financially speaking, if you are dealing with 100,000 claimants whose claims have varying levels of validity to them, that's a very different calculation from their side as compared to potentially 400,000 claimants or more. So until we know the universe of claimants, I'm not sure that we're going to see a whole lot of action from DOJ with respect to settlements, etc. And especially when it comes to these lien and offset issues, I don't know that we're going to know much about that until we see what the universe looks like. Now, saying that, I do believe that officials within the Centers for Medicare and Medicaid Services, within the Department of Veterans Affairs, I feel certain that they're in communications with DOJ about these very issues, and that they are talking about and meeting about how to address and comply with the offset provisions in the Camp Lejeune Justice Act, because at the end of the day, the burden is on the federal government to prove the validity of the offset. So I would expect those conversations to be happening.
What do you think a judge would do? I mean, I know it's a very broad, generic question, but what do you think, knowing obviously the damage on this pool of clients and how they have been treated or lack of treatment, right? A lot of them have passed with a lot of the illnesses. What do you think the court might be leaning towards?
Well, I won't presume to put myself in the shoes of a federal judge, but right. I think that the jurisdiction is important here. The fact that we're talking about cases arising out of the Eastern District of North Carolina at Camp Lejeune, and the fact that the courts that where these cases will be tried and heard are in that same district. I think that's significant. I think that it is very compelling, the stories that the injury victims have to tell, that they've told in the past and will continue to tell going forward. You know, we've heard all of these stories from a variety of angles, from a variety of diseases, and just some very sympathetic tales. And it really pulls on one's heartstrings to hear the sadness and the despair that these folks have gone through, the loved ones that they have lost over time, the babies that have died and been buried in baby heaven on the base. So there are very compelling stories here that, from a public perception point of view, could be very motivating to use to try to take advantage of that, and by way of that, streamline this entire process, perhaps. So if the goal here is to advance arguments for waiver, I certainly think leaning on the stories that these folks have to tell, just like we tell stories in the single event context to lien holders to get favorable reductions on a single event case, this in that kind of way, there's no different. At the end of the day, we're talking about human beings on both sides. Yeah. And these are some of the most compelling injury stories that any of us have ever seen or heard.
So let's play this out. So say, and we'll just use hypothetical numbers, but say, you know, you have $1 million offer, right, for a tier 1 case. I'm just using that as a round number. Sure. And say that the client has $300,000 in liens, and they are, you know, could be anywhere between Medicare, VA, TRICARE. You know, where does an attorney start, right? So you're looking to verify, first of all, what kind of coverages your client has had, what type of expenses, and whether or not they were related to, you know, the illness that they were exposed to. And then, so how do you maneuver from there to assuming that there is an offset that needs to be taken into consideration?
So, Mirena, I would presume by the way that you just posed that what this is an offer from DOJ of, here, $1 million. However, we're applying an offset of $300,000 because of VA or TRICARE, Medicare or Medicaid. So I guess the gross net to you is $700, right? So that comes into the attorney. The attorney's sitting with this offer and trying to figure out, okay, what's next? I think the first question to ask and answer is, prove to me that the 300 is legit, because I'm not sure as I sit here it is. And this is where folks who have done their due diligence proactively are going to win the day, as opposed to those who are just sitting here looking at this for the first time. Because if you've done your due diligence and you know, hey, listen, there's a lot of unrelated stuff that potentially could come our way, because one of the provisions within the Camp Lejeune Justice Act is that the medical expenses subject to the offset have to be in connection with exposure to the water at Camp Lejeune, right? Listen, I see it every day when I'm getting lien itemizations into my office from Medicare, Medicaid, name it. There's all sorts of unrelated items and charges on those payments, and we have to push back and dispute those off. So if you're receiving an offer with a $300,000 offset, you need to know whether that offset is valid or not. And if it's not valid, you need to have the evidence to prove, DOJ, respectfully, your $300,000 offset is too much because there's $180,000 worth of unrelated charges here. So instead of $1 million less 300, I tell you what, we will accept $1 million less 120. So that moves that bar up. And that's important, Mirena, because at the end of the day, that will mean more money in the victim's pocket, and it will mean more money in the attorney's pocket too, because they're not going to be able to take fees. And I know fees have been a big subject of debate.
That was going to be my next question. Yeah.
But whatever fees are going to be charged here, and I'm not here to weigh in any way, shape, or form on what that should be. Personally, whatever contract that you enter into with your client, I think is what it should be. But whatever fee is going to be collected on these cases, it's not going to be collected on the portion of the offset. It's going to be, so to borrow a tax analogy, we're talking about proceeds below the line. So the ability to minimize that offset should put more money into the client's pocket and more money into the attorney's pocket, because that's the portion they can take a fee on, I think.
Right. So is Medicare subject to the offset, or is it not?
Well, it is in the statute as subject to the offset, but I think there are potentially arguments that can be made to remove it from consideration. I think there are arguments that can be made just at an initial researching of this issue. I think that there could be collateral source arguments that could be made, which may remove it from the offset provisions. And certainly when you start to talk about, if you get it away from the offset, then you can start to look at December 5, 1980 issues as potentially allowing for full waiver. But also, we know that we get procurement cost offsets from Medicare liens, right? So Medicare is in the statute, but that's one of those that I think should be pushed on a little bit and challenged somewhat.
Yeah, and you and I had also talked about, if this scenario plays out of the offset scenario, that you're going to have, if you've got, and again, this is an estimation depending on who you ask, but based on my understanding with whether it's advertisers and law firms, that there is maybe somewhere between 250,000 to 350,000 people affected and clients that have been retained. So if they went down the path of the offset, then VA and TRICARE would be able to, they would probably collapse, right? You were talking about they're overworked. It takes a very long time. talk to me a little bit more about what that scenario looks like if that plays out.
Right. So when we talk about the VA, and when we talk about Medicare and Medicaid also to a certain extent, we're talking about federal administrative agencies that are subject to budgetary constraints, that have overworked employees, that have contractors that work on their behalf, that may or may not firing on all cylinders on a good day. But now if you're going to add on 350,000 claims to process, review, find charges, include those into an offset, and push those out the door, we really are talking about a operational process that is just too much to bear, I think, from a one-off traditional point of view. And that's why, it's encouraging to see that we've got leadership established now that are pushing for efficiencies in process that will allow for the wheels to begin turning and get some momentum here, so that we are getting to the point where we can get some movement on cases and get some resolution and get the injury victims what they have deserved for a long time.
So we had talked about the different scenario. So we've got the best case scenario is a full waiver, right? The second best case scenario is potentially asking to offset to zero. Is that the same thing?
I think it's a different way to potentially get to the same thing. So if there's an insistence that an offset be applied and not liens get waived in full, the government has the ability, I believe, to establish the amount of the offset that it wants to apply. And if they choose to offset to a number lower than the actual benefits that they've paid, although, the statute does say shall be offset, not may be offset. So I think that's something that might need to be fleshed out a little bit. But if the government chooses to apply an offset that may be less than 100 cents on the dollar for the benefits that they've paid out, sure, that's a win, right, for the injury victim. And that, again, offset smaller, net proceeds potentially bigger.
Yeah. Is there a scenario where the government may ask to offset just based on the attorney's portion versus the client's portion?
I suppose the government has the discretion to do that. Haven't thought through that scenario in depth yet, but if the government has the ability to apply an offset how it sees fit, up to 100 cents on the dollar for benefits paid out, then it could choose how to apply that portion of an offset.
Because I think if they, for whatever reason, were, again, able to be successful on the fee cap arguments, and let's say they settle at 25%, can they come back and try to offset based on that 25% the attorneys receive? Is that a scenario that could play out?
So explain that in a little more detail, as opposed to offsetting based on, say, a third.
Right. Yeah. So what I'm thinking is, say they settle on 25% of the fee, which, the argument today is, these clients should be putting more money in their pocket and attorneys should be capped. All of the reasons that, the other side is arguing for why those fees should be capped. But I don't think that anybody's thought about the government trying to offset on attorney fees in order to reduce their burden and not have to pay out as much, especially if they're offsetting the client's, liens, so to speak. Like, is that even something that they could bring up after the fact?
So there are certain programs here, Medicare specifically, that allows a procurement cost offset to the final amount owed because of attorneys' fees and costs. The other programs that we're talking about don't afford that same that procurement cost offset for fees. So could the government apply that? It could. Sure, it could. But I think there you might be getting into mixing apples and oranges to a certain extent with regards to it. If the offset is all going to be dumped into one bucket, right? And, are we going to see some sort of itemization of that offset for VA, for Medicare, for Medicaid? What's that look like? We don't have visibility to that yet because we haven't, again, DOJ hasn't really settled any cases. No cases have gone to verdict, and Navy JAG hasn't approved or rejected any claims at all. So that's one of the things that's an unknown here, I think.
No, I'm just thinking out loud. And again, there is so many unknowns, and it's, I think, uncharted territory for many. But you had also said something about North Carolina recognizing collateral source. What does that mean?
I did. So collateral source and common fund, these are notions whereby when the source of funds is coming from a separate pool of money, as opposed to the general pool of money that is sitting within the federal government, there's arguments, depending on what state, if they recognize collateral source or not, that a lien could be valid or could not be valid. Okay. North Carolina recognizes collateral source. So and again, Camp Lejeune Justice Act, we don't have any jurisprudence right now interpreting the statute itself, other than a couple one-off cases where we've gotten some opinions about the failure to exhaust administrative remedies. But we haven't had anything substantively about the application of Camp Lejeune Justice Act vis-a-vis Federal Tort Claims Act or other federal statutes where the U.S. government is the defendant. Okay, but in those types of cases, they say that the state where the claims reside, where jurisdiction lies, that's the state that we're going to recognize their law for these purposes. So North Carolina is the jurisdiction for this litigation. It is where the claims arose at Camp Lejeune. North Carolina recognizes collateral source. And importantly, when we are looking at the liens in the statute, again, VA, Medicare, Medicaid. VA, Medicaid are coming from the general funds of the U.S. government. But Medicare is something that we all contribute to through our biweekly paychecks, right? It's sitting here within the Medicare trust funds. It's a separate pool of money. So I think there's an argument to be made that collateral source could apply here, which would remove it from the automatic offset provisions and thus open up the ability to make some other powerful arguments for that ultimately could lead to waiver or drastic compromises.
Fascinating. Interesting. So if somebody is sitting listening to this and realizing, I don't want to take the chance, I would like to figure out how to be proactive, verify those entitlements. Is there a way to do it without a huge lift, right? If somebody has 500 cases, I don't think that's overwhelming. I think it's going to be a bigger issue for the firms that have tens of thousands of cases. But for the average attorney that is representing a few hundred, Camp Lejeune clients, what can they be doing on their own or with somebody like yourself to get ahead of these issues?
Yeah, so it can be done either way, Mirena. The work that my firm does in this area and others in the lien resolution space, it's not necessarily rocket science, but I mean, with the work that we do comes experience and knowledge of processes, procedures, and connections and networking, right? So firms can do this themselves, but it involves getting the right information from the victims to then take to Medicare, Medicaid, the VA to validate and verify entitlement to those programs and benefits. And that's, for me, that's the most important thing right now that the attorneys need to be focusing on is verifying entitlement. Again, you can't understand or expect to resolve a lien if you don't know that one exists. right? So you got to know which programs your clients are on, who's on Medicare and which parts, who's on Medicaid, and is it traditional Medicaid or a Medicaid MCO plan, et cetera, on down the line. And then tracking entitlement changes during the life of the litigation, because there are folks right now who may not be on Medicare, but who will become Medicare enrolled during the life of the litigation. There are folks who are on Medicaid today who may live in South Carolina, but they move to Georgia and they get on Georgia Medicaid. Well, that's an important fact, because now if Georgia Medicaid is paying benefits, there's going to be a lien that needs to be handled in Georgia and in South Carolina. So this is all work that firms can be doing right now internally or hiring someone else externally to be tracking it on their behalf.
So if somebody's doing it on 200 clients, what does that look like, you think, in terms of manpower and time and resources?
Well, Mirena, it depends on how active they want to be in the follow-up, right? For 200 claimants, that's probably a one-person job.
Okay.
It shouldn't take more than that if they know what they're doing.
Yeah.
Okay. And that includes the follow-up with it as well.
Mm-hmm. Can you get this information from the medical records? I mean, a lot of attorneys, this is an older crowd, right? And
yes.
It's difficult to get in touch with them. It's difficult to get paperwork from them. Is there shortcuts to how to obtain this information? Say you have their name, their date of birth. Do you need an authorization, or do you need, what's necessary?
Yeah, I mean, ideally, you're getting it from your intake documents, and you're getting authorization forms signed up front that would allow you to communicate with those agencies in order to verify entitlement.
Mm-hmm.
Okay. Apart from that, if folks who want to begin to do this with their current clients, they may need to reach back out and get additional information or send a document to get signed in order to do that. And again, it's more steps. I understand that.
Yeah.
But I think there's power in doing it.
I agree. I completely agree. Like you said, if you just rely, there's so much unknown about how many different directions this could go, right? Some people say there's never going to be a trial because the government is motivated to settle and to get this paid out as soon as possible. Then you have the folks that say, we're not going to even look at an offer unless we try some cases, some bellwether cases. And then you try those cases. And so it really depends in the direction. But I think to get comfortable and to say that there is going to be a waiver and I'm not going to need to worry about this, I think that's dangerous. But I think education is key. And this is the purpose of having you on, is for attorneys to know what they could be doing without feeling that this is going to cost so much money and time, or they need to bring in expertise. It's probably manageable for the average lawyer. They can get smart on this very, very quickly. It would be the right thing to do by their client, who, again, it's an older population, and it would just make things simpler at the end so that all parties are paid timely. So that's why I think it's such an important discussion to have and to bring awareness to. But as we talk about the different scenarios, like, what do you think the worst case scenario is?
Well, I suppose the worst case scenario is that there's no waivers of anything. There's no global efficiencies established. There are offsets that are coming that are different for every single victim. And the attorneys representing the victims have not done any due diligence with respect to the issue. So you're getting a different offset figure for every single one of your clients. And you don't know whether it's valid or not. You don't know whether it contains unrelated charges or not. And you're really just flying blind, and you're going to accept or reject it without having the knowledge of the validity of that offset figure.
Another thing I wanted to ask you about John, because it just triggered this thought, is I've also heard two camps on medical records, right? Because the statute says that the burden to provide medical records falls on the government. And so there are attorneys that are not getting those records. And then there's attorneys that are absolutely getting those records. And they think even if the burden falls on the government, they don't want to leave it up to the government because that may take decades. So what is your thought process on that?
This isn't for everybody, but for me, I am always in the camp of wanting to be more prepared and more in control of my cases. And saying that, to answer your question, I would be in the camp of going to get medical records for my clients because that allows me to have more control over my case than sitting back waiting for the government to do its work when it's got no motivation necessarily to prioritize my cases as compared to the thousands of other attorneys who are representing Camp Lejeune victims. At least if I'm getting my own medical records, I can have my team analyzing those records and being prepared for when the government does present their side, I'm ready to go. And I don't then have to react, analyze, and figure out what's next.
Right.
But again, that's my take on it.
For me, I'm a neutral party and I'm working closely with a lot of firms. So I hear the different perspectives. And some people are more optimistic than others, of course. And then there is always the folks that want to do everything, sooner than later to be in that position. How does it affect, do you think, so say a firm that's not on leadership, that has worked up their case, that has done the verification of entitlement, they're ready to go. Are they able to present their cases to the other side, to the government, and assuming they have everything in order, they don't need to wait for, leadership to settle first before they settle? Like, what do you think?
No, the attorneys have a duty to their clients at the end of the day. Now, as a collective group, I think it makes sense for there to be a cohesive strategy around how cases proceed within the litigation and for it to be a consolidated effort in order to get the best results for the victims. But saying that, each attorney has a duty to their own clients. And if their clients are saying, let's go, and the attorney may be saying, well, we may get better results if we wait here and let leadership get in front of this to plow the road for us. If the clients are saying, I don't care about that, I want my case resolved, that attorney has got a duty to move forward on their own to do that on behalf of their client, whether they really want to or not. So they might have to go against their internal instincts of wanting leadership to plow the road for them, and they might have to move forward because their clients are telling them, move forward.
We had also talked about a group of clients who are not going to have representation, legal representation. And again, there was a group that was adamant about not hiring a lawyer for the purposes of being represented. They filed their own claim. They're monitoring this, themselves.
Sure.
What can they be doing and to help their own case?
Well, I will say that for any unrepresented claimants that are victims of Camp Lejeune and that are seeking justice here and trying to go it on their own, highly encourage you to hire an attorney to represent your interests. But having said that, if you are proceeding on your own, you're going to have to confront these same offset issues that we've talked about during this session yourself. And you're going to have to figure out what this looks like and what it means for you. And that's potentially a tall order. These are, as we're talking about today, there's a lot that we don't know. That I sit here and do this stuff day in and day out, and it's the focus of my practice. And there's a lot about this that I will admit that I don't know right now and don't have visibility to. In the coming months, we're going to get that knowledge and visibility to this and get a plan established going forward. But for any unrepresented claimants out there, you're going to need to address these liens, these reimbursement obligations, these offset obligations, and do so in a way that's going to minimize what you have to pay back in order to maximize the amount of money that you're going to be able to get for your claim.
Mm-hmm. Any thoughts in conclusion of this topic? I want to move on to some other areas that you focus on. Any final thoughts on Camp Lejeune lien resolution? Yeah,
let me talk for just a minute about things other than VA, Medicare, and Medicaid. Mm-hmm. Because just because certain lien obligations aren't verbalized within the statute doesn't mean they can be ignored. We think about private and ERISA liens. We think about FEBA liens. A lot of these victims, may have these liens in play. And we all know there's been a lot of publicity about this litigation for a variety of reasons. Well, the Rawlings of the world are tuned in, and they are also developing plans to seek reimbursement outside of the VA, Medicare, Medicaid context, right? So there needs to be a strategy employed to handle those obligations in a way that minimizes the paybacks as well. So I don't want those types of obligations ignored because of the fact they're not enumerated in the statute itself. One other thing to consider, again, the statute doesn't talk about this, but just like any sort of other matter where an injury victim is receiving proceeds, whether it's settlement proceeds or they win a verdict against the federal government, the receipt of settlement proceeds can have an adverse effect on future medical coverage for Medicaid and Medicare. And there needs to be thought about that. And maybe the thought is simply asking the clients whether they want those benefits protected as part of the process, yes or no. Because if the clients do not want those benefits protected, terrific. Don't have to worry about it. Let's get that in writing for our file and let's move forward. But if they do want Medicaid post-settlement, Medicare post-settlement protected, ready and able to pay bills going forward, well, there needs to be some sort of thought or plan against making sure that's going to be the case. Right. This litigation is no different than any other MDL in that kind of way, but for the fact that right now, at least in a global MDL resolution program, you've got Medicare. Their figure is inclusive of past and future medicals. We don't have that in place right now here. So again, we don't know if the offset that's coming will include that or not. By the letter of the statute, it only has to include past benefits paid, which is why I raised the issue. What's going to happen with future Medicaid or Medicare coverage after these claims are resolved? Something to think about and monitor, I think.
Yeah. So do you think would be fair to ask clients now whether or not they want to protect future benefits and how they plan to receive their settlement? Is that too premature?
I never think it's too premature to ask the question, do you want your benefits protected through this process? It may be premature to ask exactly how you want to receive your settlement proceeds because we are a ways away from that, I think. Mm-hmm. But to ask them as part of representing you, do you want our office to make sure that your future Medicare or Medicaid coverage is protected? I don't think that's premature.
Yeah. I think the only reason why I brought up the idea of having a conversation about how you're thinking about receiving your settlement is because they don't start to think, and this is from my experience with clients, is they don't start to think about that until the question is asked. Even if there is, the case is 2 years away from resolution, 3 years away, they just haven't really thought that. And they don't even know what the options are. And a lot of folks have somebody that they know or in their family that can help them with this and prepare them and get them ready, or seek professional help, people that specialize in doing this, so that you are setting up that trust, or working with your estate planning attorneys to make sure that you are not, by taking the funds, hurting yourself in other ways. Right?
Exactly. I think it's a good question to ask if it's asked in the right way. I'll say that. Because what we don't want to do is we don't want to set up an expectation on the victim side, thinking that, hey, money's coming soon, right? Because I don't think we're there right now in this litigation for that.
Well, unfortunately, that was happening during advertising, right? There was advertising out there saying you can claim $50,000 today, file. So I think, unfortunately, and I think a lot has happened with this MDL, with this, well, it's not an MDL, but with this case that has been, tragic in the way that advertising was handled, client communication was handled. These folks were bombarded with calls and were solicited in ways that we haven't really seen before.
Yeah.
So it's really heart wrenching to hear some of the stories, and then that's part of why a lot of people don't even want to hire an attorney, is because the advertising turned them off. So I think, like you said, having the right type of conversation in the way that you are educating a client about their options, whether settlement happens 6 months from now or 3 years from now, and hopefully sooner than later, it allows them to think about what they want and how they want to take their funds. Anything else on that? Because I know I'm sure I haven't asked all the questions, but I want to make sure that you can convey on this platform everything that, you've been thinking about and researching on this topic.
Yeah. So, our research continues. We are working on this litigation every day on our side, further analyzing the offset provisions, thinking about different angles, and thinking about what might come to pass, right? At the end of the day, the goal here is to maximize the proceeds that the injury victims can receive, and protect their future coverage if they choose to have their future coverage protected. That's the world that we live in and day out. And that's our small little contribution to this team and group effort, moving this litigation forward. So we're continuing to do that on our side, and we are working with certain clients around the country currently and actively to help prepare them for the day that they're going to get offers on their cases from DOJ, and provide support for those who seek more information about these types of things. We've established a website, CampLegeuneLienResolution.com, that one can go to and visit a blog and look at some of the cases that have come out and been ruled upon already, that I referred to earlier in the session regarding the failure to exhaust administrative remedies. We're putting status updates on the litigation up there now. We've also posted a link where one can obtain our lien resolution white paper that we are updating once every 6 months to contain the current thoughts and research that we've conducted, as well as bring up to speed with respect to status of the litigation.
Well, it's wonderful that you're doing this work and being so proactive. I know it's your job, but there's so many different areas you could be focusing. I know this is near and dear to you, as I know that you also have some ties to North Carolina, but it's really great that you're leading the efforts on this front. Obviously, outside of working in the mass action world, you also obviously heavily focus on single event cases. And you are also incredibly well thought out on protecting injury victims post-settlement, access to Medicare and Medicaid benefits. Can you speak a little bit more to that and lawyers who deal with these issues every time that they do resolve a case?
Yeah, and really, Mirena, that's where I started in this world over 15 years ago, was focusing on future Medicare coverage. And back then, there was a hotly debated topic about whether Medicare set-asides are required, yes or no. And that's been a moving target and remains a moving target to this day. But the statute remains the same and has during that entire time. And it says that Medicare won't pay where payment has been made or can reasonably be expected to be made. So there are situations where Medicare expects to not pay certain future medical bills, that they expect the injury victim to pay out of their settlement proceeds when they've been compensated for future medical expenses. So the work that my firm does in conjunction with the personal injury attorney is to review the facts of the case in light of the Medicare Secondary Payer Act and other regulations and provisions to figure out, is there a need to make sure that Medicare is not paying $1 after a settlement, yes or no? And if there is an obligation, what's it look like? And how can it be managed? And how can it be funded? And what's the proper time to begin to bill Medicare in a way that Medicare is not going to reject bills, not going to pay bills, but then chase the injury victim for reimbursement? So that's the work that I founded the firm on in 2016, and it continues to be the most popular service that we provide our clients around the country today.
And you do an amazing job. So for anybody that needs this service and wants it done right, John is amazing at it. So I've worked with him on preparing several Medicare set-asides for my clients. So talk to me about lien resolution. Again, these are topics that are not sexy topics to lawyers. Like when you bring it up, they're just like, eh. And it's that sort of attitude that sometimes, because they don't want to deal with it, and then it tends to prolong the case and upset the clients in the end. And it's annoying. So what could they be doing to focus their energy on doing what they do best and getting the liens out of the way sooner than later, which is exactly what we talked about for an hour on Camp Lejeune?
Yes. So, when I was thinking about and working at Garrettson doing MSA work, I made an observation, and I looked around the country at all the clients I was working with in that capacity. And I asked myself this question. There's a lot of people out here that like to work with attorneys about these issues. They like speaking to a lawyer about these issues, but there's no law firms out there doing this kind of work. Why isn't anybody out there giving legal advice about lien resolution and Medicare set-asides and all this other stuff that no one wants to touch? And, I thought about that for a while and eventually came to the conclusion, well, no one wants to do it because no one really has a handle on it and wants to build a practice around it. And, I decided that's where I'm going to hang my hat and hang the shingle, so to speak, and open up the law firm. And, we're now 7 years into this, and we've got a terrific track record of partnering with personal injury attorneys and getting great results on liens. For example, we currently have an 86% reduction rate in traditional Medicare liens. We've got a 77% reduction rate on Medicare Advantage. We've got a 64% reduction in Medicaid. We've got a 91% reduction rate in VA liens. And this isn't just one single instance. This is every single Medicare, every single Medicaid, every single VA lien that our firm has ever been hired on. We're getting these terrific results that I think are above and beyond what the practitioner themselves can achieve. It's not to say they can't, but we do it day in and day out. And when firms partner with us to do this type of work, we act as their back office, for lack of a better term. So I've got a legal degree. I've also got a business degree. We plug in as their back office. We've got 22 people around the country right now who focus on this stuff. And by outsourcing lien resolution, you're able to free up time within your firm to do whatever else you want to focus on. That might be increasing case intake and focusing on the front end, getting more cases in the door. It might mean beefing up your paralegal and associate attorney staff to conduct more discovery, to find any additional layers of insurance coverage that might be hidden because you're spending more time on it, right? All of that time spent on the case is going to increase the amount of the demand that you can serve on the carrier on a case-by-case basis. And that's going to, in turn, increase the amount of the settlement in that one case, which increases the fees for the attorney to take on that one case. Now, replicate that over 100 cases, 500 cases over a year, and you start to see a firm becoming more profitable simply because they outsource lien resolution to a competent other outside organization to handle on their behalf. So we're really here to partner with attorneys in that kind of fashion. We love working with folks on a one-off basis when it's a complicated case, a catastrophic case. We get great results there, but the clients of ours who get the best results are those that work with us comprehensively because it allows them to scale their practice.
Yeah, I have seen the impact that it makes in law firms, especially if they are high volume law firms, to be able to have the right folks that, again, have the expertise, the experience. But truly, I hadn't really thought about the business side of things, right? Because it does pull them away. It's time and resources. They're not getting paid after the case is resolved, right? That's not something that you're getting paid on anymore. So it makes a lot of sense. Well, John, it's been a pleasure to have you and to speak with you. I always walk away knowing more after I'm done talking to you. So thank you for everything that you do, all the people that you help. And I look forward to continuing the conversation with you in this area, as I think there is a gap, and a lot of people need the information to be able to do better in their practice. So thanks so much.
Mirena, the pleasure's mine. I appreciate the chance to sit with you for a few minutes today and look forward to doing it again soon.
Stay tuned for upcoming episodes available on popular platforms such as iTunes, Spotify, and YouTube.